All right. Thanks. Yeah. Introduce Judge Berger to my right and Judge Lambert to my left. Case on the docket is Hope versus State. Each side will be allotted 15 minutes. Let me get this reset. Okay, appellant may proceed.
Got your curtain open there.
Yeah.
I hear about that.
All right.
May it please the court, opposing counsel. Your honors, if I may, I'd like to reserve 3 minutes for rebuttal.
Okay.
All right. Well, in this case, I'm going to be upfront. I am asking this court to adopt a dissenting opinion from the first DCA in the Eady versus State case. However, I believe that the Eady dissent is supported by Supreme Court of Florida precedent in the McCrae case, because in the McCrae case, well, I'll back up. And the issue, though, we have a pro se litigant who was removed from the courtroom, and
Well, the trial court, I think, made a finding at one point that he just voluntarily absented himself. I mean, he said, I'll go, I don't want to stay here. And, I mean, he was, and I've tried lots of cases as a circuit judge, and, I mean, lots and lots of them. This is probably one of the most disruptive defendants that I have observed, either personally or on a cold record. And so at what point, if the trial court made a finding that he voluntarily left on his own, then where do we go from there?
okay, well, no one disputes the fact that his removal was proper. I agree with you. He was incredibly disruptive. However, being disruptive does not mean he completely waived his constitutional right to have any representation at all.
Where do you draw the line between somebody just leaving voluntarily and somebody being removed? Because it seems to me like that, the line may have been crossed to the point where he just voluntarily left.
Okay, well,
So if you voluntarily leave, then what? What standard do we apply at that point?
if he voluntarily leaves, then I believe the trial court should at the very least ask, do you want an attorney here to continue to represent you in your absence? But I would also note
He had already declared that he wanted to represent himself, and the court had appointed a standby lawyer, right?
Yes.
So let's assume that, and at one point the trial court did make a finding that voluntarily absented himself.
Yes,
So if that's the case, what's the trial judge supposed to do?
Okay. What I believe, in this case, though, even though it is described as voluntary, I would note that in the Eddy case cited in the state's answer brief, which was a Rhode Island case, the Rhode Island case actually made a distinction that the first DCA declined to make, which is there is a difference between a defendant announcing, I do not want to participate in walking out, and a defendant being forcefully removed from the court. So despite it being described as voluntary, he was in fact taken and removed from the court because of his disruptive behavior, and this rule I am asking this court to adopt.
Where do you draw the line between somebody that's intentionally disruptive, and I think the trial court did make findings that he was intentionally doing this because he didn't want the trial to proceed. Where do you draw the line between somebody that intentionally is disruptive to the point where he knows that the trial judge is going to have to remove him? At what point does that become a voluntary absence? Because he knows what's going to happen, and he keeps doing it to the point where he wants the trial judge to remove him. Isn't that a voluntary absence of sorts?
In a sense it is, but also in a sense it is not, because he did not choose to leave. And I would also, you referenced the trial judge's warning. The trial judge actually warned him that if he was disruptive, his self-representation would be terminated, which indicates that his appointed counsel would be reappointed. But in this case, the trial judge did not fully carry through on that threat. The trial judge said, if you continue to be disruptive, I'm going to terminate your self-representation and remove you from court. And the Supreme Court of Florida said that in a case like this, a trial court has two options. In the McCrae case, it outlines two options. Option one, terminate self-representation. Option two, terminate self-representation and remove him from the courtroom. The trial court partially chose the second option by removing him from the courtroom, but did not fully implement that option by terminating his self-representation, because otherwise, as the Oregon courts that I cited in my brief said, the state is at that point arguing against an empty chair. He is left completely unrepresented, which is not proper. Again,
You didn't want this lawyer. I mean, there's a difference between, at least in my mind, where a defendant makes a choice saying, well, I want to represent myself, no offense to my counsel, but I want to do it myself because it's my life and I think I can give it a better shot. I mean, your client made it abundantly clear repeatedly, why are you forcing me to go to trial with this attorney? I've been so verbal and on the record, it's not in my best interest to have this attorney. Trial's not the problem here, it's my counsel. I've told you that. I told you from the beginning I don't want to go to trial with this attorney. I don't have a fighting chance for my life with this attorney. So now you're telling us that when the judge says, fine, I'm not going to force that attorney on you. You want to behave the way you want to behave and absent yourself voluntarily? You've set the table here? Tough luck. That seems perfectly reasonable to me.
And he's in fact, and to put on that, Mr. Hope told him, and you can take me out of the courtroom.
That was earlier, but he then retracted that request when he instead chose to go pro se. At the time he said, you can take me out of the courtroom, he was still represented by counsel, but then he changed his mind and said, I want to stay, I want my attorney to go. And to answer Judge Lambert's concern, the Supreme Court of Florida made it abundantly clear you can reappoint counsel even over the previous request to go pro se when the pro se defendant is removed from the courtroom.
You have to.
I believe.
Sir, I
that-
mean, we're all trial judges up here, and we might have said, you know what, I'm appointing standby counsel to be your counsel because it's easier to do it that way than other ways. But you're saying as a matter of it's a structural violation of the trial, the conduct of trial. When you as a trial judge make that discretionary call after the guy has repeatedly told me, you're basically going to ruin my life if you give me this lawyer again. Okay, then I won't do that. Behave yourself. Can you behave yourself? No, I'm not going to do that. We're going to take you out. I don't care. I'm not going to behave myself. This seems to be your client's the one that's caused all the problem here, clearly, abundantly, and now you're coming back and saying, geez, he really didn't mean it.
Well, I'm not saying he didn't mean to misbehave. As I said, he misbehaved. He got himself removed from the courtroom. That is proper. What the trial court
He
did
basically
next.
admitted that he was doing all this to stop the trial. He didn't want the trial to go on, and talk to me, and all this nonsense. And I mean, he admitted he was doing this to stop the trial.
And that is what.
And it seems to me like he just walked right on out on his own.
Yeah, but that is, as I said, was entirely proper to remove him, but counsel should have been reappointed because otherwise the state was arguing against an empty chair. I believe the logical extension from the McCrae case is to go from you can reappoint counsel to must reappoint counsel.
Could the trial judge have simply said, okay, you want to represent yourself, go through Ferretta, qualifies him under Ferretta, and then says it's on your own, counsel, you can go, you're discharged. Could have done that, couldn't he? The trial judge?
Well, the appointment of standby counsel is discretionary so
Right.
long as someone is present. However, upon his removal from the courtroom, trial counsel should have been reappointed. As I noted in the brief, so far there are about 7 other states that seem to mandate reappointment of counsel.
11th Federal Circuit clearly disagrees with you.
Let's see. The 9th Federal Circuit.
At the
mandates-
11th Circuit, which we're in, and I know their precedent's not binding on us, I understand that. But I mean, the 11th Circuit has raised the question that I would say is, this trial judge has been placed between a rock and a hard place by your guy, because if he says, okay, I am now reappointing this standby counsel, even though you've told me repeatedly you don't want this guy, then it's going to be you've interfered with my right of self-representation when the standby counsel finishes the case as the appointed counsel. They 11th Circuit clearly anticipated that, didn't they?
Well, I believe
They wrote
is-
that in their opinion, didn't they?
Let's see, in the 11th Circuit case, though, that was a defendant who voluntarily walked out, not a defendant who was removed for misbehavior. And I would also note that the Supreme Court of the United States in Ferretta said self-representation can be terminated when the defendant is being disruptive. That is the case the Supreme Court of Florida relied on in McCrae when The Supreme Court said trial court properly terminated self-representation because the client was being disruptive, and Supreme Court clearly said there are two options. Both involve terminating self-representation. The Supreme Court did not create a third option of remove the defendant and continue with no one there at all, because as the Supreme Court, as the court in Connecticut said, one of the benefits of having someone there is to avoid the jury drawing an adverse inference. And as the courts in Oregon said, you have the right to not attend your trial. You have the right to self-representation. You have the right to some representation. Those first two rights, the right to be present, the right to self-representation, can be waived, but that third right, the right to have any representation at all, cannot be waived, because otherwise the state is arguing against an empty chair. It's a breakdown in the adversarial process.
So that any defendant that's representing himself, that doesn't like the way the trial's going, can just walk out and essentially get a new trial?
He can not walk out and get a new trial, because, as I said, the error is in the trial court not reappointing counsel. In another state, I believe, let's see.
But what about, but in that scenario where I'm saying, say, standby counsel is not appointed, and the defendant's just representing himself, and he walks out, voluntarily absents himself from the courtroom, the trial just has to stop at that point?
At that point,
he gets his wish to have the trial stopped or have a new trial because we got to now appoint counsel at this time to represent him, or?
I don't believe that would result in the trial stopping. It would be a very brief recess.
It's the defendant declaring a mistrial, not the court thing, because the defendant's has complete control. He wants to walk out, he's representing himself, he walks out the door, boom. According to your theory, that's an automatic mistrial. He declares it, not the trial court.
No, my theory is not automatic.
It doesn't make any sense to me, but, you know.
My theory is not automatic mistrial. It's court says, you are out, your counsel is now back in, and the counsel would...
Well, what if there was no standby counsel there?
If there was no standby counsel, then, I see I'm
Well, answer
in
my
my
question.
rebuttal. Yes, I will answer your question, Your Honor.
I'll give you a little extra time. I don't know. Go ahead.
Okay. If there is no standby counsel, then the trial judge would appoint counsel either...
In the middle of trial?
You can't
In the middle of trial, you're just going to pull somebody out from the conflict counsel list and say, oh, by the way, you know nothing about this case, but because this guy wants to misbehave and there's no standby counsel, I need to appoint somebody here so it's not an improper trial. That makes zero sense to me, having tried hundreds of cases as well, like the rest of us here.
Okay. All right, Your Honor,
You're doing really good for somebody that's got a tough case. You got a tough case here, but you're doing a really good job, so.
Thank you, Your
I don't
Honor.
want you to be discouraged or anything.
Thank you, Your Honor.
Okay.
If I may, I would like, I do have to still answer Judge Lambert's question. I would say in that situation, it would obviously be very difficult, in which case I would say the client has effectively waived any ineffectiveness claim he would have in the future. It would not take too long for at least an appointed counsel to sit there, at the very least, object to anything improper going forward. Obviously, a newly appointed counsel, or if possible, appoint a counsel previously familiar with the case. In this case, let's say standby counsel had not been reappointed.
Let's say there never was a standby counsel.
That is what I'm saying. Say, hypothetically, standby counsel had not been appointed, counsel is just discharged. The trial court could have called counsel back and said, you are back on this case, I know you missed part of the trial, but you were at least familiar.
I mean, what if the counsel was discharged 2 months before trial? I mean, that's...
Yeah,
I mean, I know they have counsel initially, but if the judge, if the discharge the counsel 2 months before trial, and then call them at the last day of trial, say, oh, you remember that trial, that case you were in 4 months ago? Come on and finish. Good luck. Do the best you can. We don't want to have a charade for a trial here.
Right, well,
Okay.
at that point, though, I would argue a counsel who is barely familiar with the case is better than no counsel at all, because a counsel that at least is there to object to anything improper by the state. For example, when I was rereading the record yesterday, I noticed a arguably improper error by the state, arguably not improper, but arguably improper, because no one was there. No one was there to object. A trained counsel.
His counsel did did a few things. It participated in the jury instructions, isn't that right? And
Well, she did participate, but as I noted in the reply brief, that was arguably going beyond her role as standby counsel because she had not been formally reappointed. I believe the trial court should have formally reappointed her. She would have finished the trial and see, I am
okay, your time is exhausted, actually, so I'll give you an extra minute.
Okay, thank you, Your Honors.
Okay.
Good morning, Your Honors, and may it please the court, counsel. My name is Marjorie Vincent Tripp, appearing on behalf of the state of Florida. The issue in this case is about choice, specifically how this particular appellant chose to conduct his defense. He clearly asserted his right to self-representation. He validly
Let me ask
waived.
you this, is there a difference, do you see a difference between a defendant that goes in, has counsel, then decides he doesn't want counsel anymore, and a Feretta inquiry is competent to proceed, represents himself, standby counsel is appointed, and then he's absented, so the situation we have here, versus a case where standby counsel is not appointed. Is there really a difference in how the trial court should proceed? If you've got the defendant out, and then, I mean, all the court needed to do was say, okay, standby counsel, start back up again. This was not an attorney that was unprepared. This was an attorney that had prepared for trial and had participated in the trial.
Correct, but it was also an attorney that this defendant clearly did not want. And I don't really see a difference in either case. The ultimate point is that this defendant chose to assert his right to self-representation and chose to validly waive counsel. And it was to the trial court's discretion as to whether standby counsel was or was not appointed. In this case, I think the court appointed standby counsel based on the prior behavior of this particular defendant. But ultimately, this defendant had control of how he wanted to conduct his case. He clearly stated on the record that he was attempting to disrupt the trial because he didn't want that attorney. And he also stated at another point to the court, my life is on the line, and Your Honor, yes, I would do anything to stop that, meaning anything to stop this trial.
But under Feretta and then the Florida Supreme Court in Jones, basically, when they're talking about standby counsel, one of the things they say is, you can appoint standby counsel even over the defendant's objection, and the purpose might be to represent the defendant in the event it becomes necessary to restrict or terminate self-representation by shackling and gagging the defendant or by removing him from the courtroom. So, I mean, that Feretta kind of anticipates that, your self-representation, and we tell them when we do the Feretta inquiry that, we're going to let you do this, but if you misbehave, you might lose this right. You understand that? And they all, yeah, okay, gotcha. And then, then when it actually happens, that's why the standby counsel's there. And this theory that this judge says, well, do you feel like jumping back into the fray? That's an intriguing comment that certainly I've never made. That seems like an unusual thing to request of a standby counsel. Like, who would want to get back in?
Well, I don't think what the judge did in this case defeats the purpose of standby counsel. This defendant had a specific strategy. This is a defendant who had 14 prior convictions, admittedly had at least gone through 2 prior trials, so he was familiar with the system. He decided to concoct this theory, and I think the record supports that this was a trial strategy he specifically adopted. On the first day of the trial, after the court allowed him to represent himself, there was a break in the proceedings, and the defendant alluded to possibly getting a continuance, and the court said, no, you cannot have a continuance mid-trial. There was further discussion, and it went back to the point where the defendant specifically requested a continuance, and the trial court specifically told him, quote, you're not getting a continuance in the middle of trial unless there is some emergency. There's no emergency here. So I think the record supports the finding that this particular defendant went back to his cell after these proceedings ended the first day of trial, concocted this trial strategy where he was going to feign mental illness in order to either obtain a continuance or ultimately get a mistrial in this case. This was was a choice, a strategic choice that this defendant made in conducting his defense, and it failed in this case. So this
He's
is,
an obstructionist defendant, but there's the standby counsel. You say, okay, look, this guy's going to behave how he's going to behave. We're taking him out. You're in. No ifs, ands, or buts. That's why we have you as standby counsel, for the exact reason that we might have to terminate his self-representation by misbehavior, obstruction, trial strategy, whatever. Finish it off the best you can, and then that guy over there, all he's talking about is clerical error then.
well, I think, Your Honor, there's a fine line, and it's a distinction, but it's a fine distinction nonetheless, between a trial court determining that a defendant is unable, for whatever reason, to continue representation and therefore not able to participate in the proceedings versus a defendant, him or herself, choosing not to participate. In this case, this particular defendant chose not to participate by abandoning his trial via feigning mental illness. The trial court twice attempted to question this defendant, whom Dr. Danziger said was clearly competent to proceed. Twice attempted to ask this defendant, do you want to participate? And this is a trial judge who was extremely patient with this defendant. There were 2 Nelson hearings conducted. The trial court, in 3 instances, this defendant disrupted the proceedings, was very patient with the defendant in all instances, explaining to the defendant why certain things could be done one way and not the other way. But this defendant persisted with this strategy. And I think where a defendant chooses to conduct a particular trial strategy by abandoning his defense, then the court is between a rock and a hard place. And in this case, as the Judge Lambert mentioned, had this court said, okay, standby counsel, you're back up, I guarantee on appeal right now, the issue would be that the trial court violated this defendant's right to self-representation. I think it would set a bad precedent in this case if this court were to reverse, because other defendants would know that, hey, I can go into court, I don't like this attorney, I don't like the way my trial is going, and I'm going to do everything that I can to try to stop the proceedings. And we'd be rewarding defendants for this type of behavior rather than holding them accountable for the specific strategies that they choose to engage in defending themselves. So based on...
So if the defendant's strategy was, I'm going to just sit there and say nothing, I'm not going to talk, I'm not going to respond to the judge, I'm not going to do closing argument, that's a trial strategy, and at that point, he is really not acting as an attorney or attempting to act as an attorney, that the trial judge would be within his or her discretion not to appoint standby counsel. Because
Absolutely, Your Honor.
That's a strategic choice he's made, Mr. Defendant here. His different strategic choice is he's going to fake mental illness and start talking to voices and doing whatever he can. So he's made a strategic choice to stop participating in the trial. That's how his representation is, and it's not really he's not really terminating his self-representation.
Correct, Your Honor. And I believe it was the worthy opinion out of Colorado that specifically recognized that the issue is really not the presence of the defendant. The issue is the choices that the defendant makes once he or she chooses to represent him or herself. And in this case, this defendant came up with this strategy, and it's clear he had strategies throughout this trial, even before he asserted his right to self-representation. And it was his right to conduct his trial in the way that he saw fit. It didn't work. He did not get the continuance that he wanted, or maybe the mistrial that he was ultimately seeking, but nonetheless, he was entitled to conduct his defense however he chose. And the court has recognized that a defendant can sit at the counsel table silently, not conduct cross-examination, not make opening statements or closing arguments. And ultimately, again, it boils down to the defendant's choice. And in this case, the defendant chose to conduct his strategy in this manner by abandoning his trial on the day, by the way, he was supposed to present his defense, and chose to abandon the trial by feigning mental illness. And in this case, the court made the correct decision where this defendant validly waived his right to counsel, did not reassert his right to counsel, and decided to represent himself. And for all those reasons, we would ask that this court affirm unless there are other questions.
Okay. Thank you. I'll give you 1 minute.
Thank you, Your Honors. All right, I just wish to answer 2 of the state's comments. The states argued that had standby counsel been reappointed, I would be arguing that would be error. I would point out that under the McRae case, it clearly says standby counsel can be reappointed, and I believe the logical flow from that is standby counsel must be reappointed. And I would also argue that the reappointment of standby counsel, or in this case, rewarding new trial for the failure to do so, is not rewarding the defendant. It would merely be saying trial judge, we recognize the difficult position you were in, but proceeding without any counsel whatsoever was error. Standby counsel should have been reappointed, and that is, I believe, how the trial court should have proceeded, and that would be the sole reason for remand. It would not be for the purpose of rewarding the defendant. It would be just saying, trial court, you're in a tough position, but you made the
Okay.
incorrect decision
You're
by
over time.
not reappointing.
All right, thank you.
Thank you, Your Honors.